Hello friends, I am Arpit and I am here with today's analysis. Today is 12th of December and we are going to discuss one very important topic which is in news. You might be guessing it right, and that topic is Article 370. The judgment on Article 370 has been given by the Honorable Supreme Court yesterday. So actually you can see two topics on the screen, but yes, the second topic, that is Article 35A of the Constitution, is a related topic to Article 370. Article 35A was inserted in the Constitution in the year 1954, and it was inserted taking, I would say, inspiration from Article 370, which was already there. Article 370, which gave special status to the state of Jammu and Kashmir. Actually, this status was extremely special. Special status other states also enjoyed, but this was extremely special. Why? Because Jammu and Kashmir was allowed to form its own constitution. The Constitution of India was not applicable in the state of Jammu and Kashmir except for Article 1 and Article 370 itself. The laws made by the Indian legislature, that is the Lok Sabha and Rajya Sabha, they were not applicable without the consent of the Jammu and Kashmir state legislature. Apart from laws made on three subjects, that is communication, defense, and external affairs. Those were directly applicable, but yes, on other topics, the laws made were not implemented without the consent of Jammu and Kashmir state legislature. That is why, this special status was extremely special. Now, in 2019, the government of India abrogated this Article 370, means government of India took away this special status of Jammu and Kashmir, and it was challenged in the Supreme Court. It had to be challenged. Now, the Supreme Court has finally given a verdict on this. A constitutional bench comprising of 5 judges, including the Chief Justice of India, has given a unanimous judgment, means 5-0 judgment, stating that the abrogation of Article 370 was legal. There was nothing malified in that, which simply means that the abrogation is upheld. So let's get into the details of these two topics. So today's lecture, we can say, completely dedicated to Jammu and Kashmir, Article 370, Article 35A. What was the, I would say, judgment, what was the conflict all about, or what were the arguments by the petitioners, all we'll see in today's topic. Now, the Supreme Court judgment on Article 370. When we got independence in 1947, Jammu and Kashmir was a princely state. The princely states had 3 options: be part of India, or be part of Pakistan, or remain as an independent country. Jammu and Kashmir, a princely state with around 77% of Muslim population, ruled by a Hindu ruler, Maharaja Hari Singh, chose to remain independent. Go neither with India, neither with Pakistan. But Jammu and Kashmir was attacked by the Pakistani tribesmen along with the Pakistani army. And it is when the Raja of Kashmir approached the government of India, that is Jawaharlal Nehru, for help. Jawaharlal Nehru extended military help to Jammu and Kashmir, but on one condition, that Jammu and Kashmir be part of India. Jammu and Kashmir became part of India, but Maharaja Hari Singh also kept one condition in return. He said that I want some special status for my state. And that special status was given in the form of Article 370 of the Constitution of India. Article 370 of the Constitution of India empowered Jammu and Kashmir to have its own constitution. Article 370 also enabled the, I would say, non-applicability of the Indian Constitution on Jammu and Kashmir except for Article 1 and Article 370 itself. It gave certain amount of autonomy to Jammu and Kashmir, where the laws made by the Indian Parliament will not be applicable without the, I would say, concurrence of the State Legislative Assembly of Jammu and Kashmir, except for 3 topics or 3 subjects, that is external affairs, defense, and communication. For these, directly the laws made by Government of India, the Parliament of India, will be applicable without the consent of the Legislative Assembly of Jammu and Kashmir. But in 2019, the Government of India removed or abrogated Article 370, that is a special status given to Jammu and Kashmir. This was a long standing issue, and when the government did it, Jammu and Kashmir was under president's rule. Obviously, the removal of Article 370 had to have certain legal repercussions. It was quite natural. So there were some 23 petitions in front of the Supreme Court, which the Supreme Court started hearing in this year's August, that is August 2023. The petitions were about the way Government of India abrogated Article 370, because for its abrogation, the Government of India, the President basically had to take, I would say, concurrence of the Constituent Assembly of Jammu and Kashmir, which was responsible for making the Constitution of Jammu and Kashmir. However, the Constituent Assembly ceased to exist in 1957. So the petitioners felt that, Article 370 is permanent, it cannot be revoked because, the Constituent Assembly is not existing. To whom will the President, take advice of? And, some petitioners also claimed that the concurrence of the state government or the recommendations of the state government were not taken before abrogation of Article 370. It was unanimously done by the Government of India in a wrongful way. That was the matter of petitions. The Supreme Court started hearing on these petitions in August 2023, and finally on 5th of September 2023, the Supreme Court said that we want to reserve our judgment. We want to look into the details of this matter, and then we will come out with our decisions after we review this matter in detail. Now finally, that is yesterday, 11th of December 2023, Supreme Court has come out with its verdict and has said that abrogation of Article 370 was completely legal. It was a constitution bench giving this judgment, means at least 5 judges are there, and 5 judges were there in this bench. This judgment was unanimous, means all the 5 judges, gave a judgment in this favor that abrogation of Article 370 was legal. There was nothing wrong in that. So Article 370 stands repealed, stands abrogated, and the special status given to the state of Jammu and Kashmir no longer exists according to the Supreme Court also. So let's look into the details of this judgment. The Supreme Court judgment on Article 370, basically a 5-judge bench was there and a 5-0 unanimous ruling was done or was given on the Union Government's 2019 move to abrogate Article 370. The abrogation ended special status conferred to the erstwhile state of Jammu and Kashmir. Now, what was this special status? We will see in the future slides. The court held the constitutional order that revoked Article 370 as valid. This Article 370 was revoked or abrogated by a constitutional order issued by the President. And that issuing of that constitutional order abrogating Article 370 was stated to be valid by all the 5 judges in the Supreme Court. A 5-judge constitutional bench presided by Chief Justice of India, Mr. D.Y. Chandrachud, had reserved its verdict on as many as 23 petitions in the matter on September 5 this year, after 16 days of hearing, which began in August 2023. Now, what is Article 370? You should know the details of it, then only you will be able to understand the entire story. Article 370 is the first article of Part 21 of the Constitution, temporary, transitional and special provisions. Now the word temporary is very, very important. Since it was temporary, it could be removed anytime. But the petitioners, some of them, were advocating that it is permanent in nature because it can only be removed with the prior consultation with the Constituent Assembly of Jammu and Kashmir. The Constituent Assembly of Jammu and Kashmir, which was making the constitution for Jammu and Kashmir, ceased to exist in 1957. And since there is no such body existing, the President cannot take advice of any of such body. Hence, it is permanent. It was basically the argument given by Advocate Shri Kapil Sibbalji, who was fighting the case. on behalf of these petitioners. Now it exempts Jammu and Kashmir from application of Constitution of India. Article 370 means Constitution of India will not be applicable except Article 1 and Article 370 itself. Article 1 comprises the names of all the states and UTs and permits the state to draft its own constitution. Now this is what the Constituent Assembly of J&K was doing. Article 370 described as a tunnel through which the constitution was applied to J&K. Means the Constitution of India was applied to Jammu and Kashmir through this tunnel, and this tunnel was Article 370. Means only Article 1 and Article 370 could be applied. So this was there. It restricts the Parliament's legislative power in case of Jammu and Kashmir. Means, the Parliament could make laws only on three subjects, that is first defense, second external affairs, and third communications. The Parliament could make laws for other subjects also, but if laws made on other subjects by the Parliament of India and they have to be applicable to the state of Jammu and Kashmir, they were only applicable after the agreement or concurrence by the State Legislative Assembly of Jammu and Kashmir. If the State Legislative Assembly of Jammu and Kashmir allowed those laws to be applicable in Jammu and Kashmir, then only those laws were applicable. Otherwise, they were not applicable. But laws made on these three subjects by the Parliament of India, they were applicable automatically to the state of Jammu and Kashmir without the concurrence of the Legislative Assembly of Jammu and Kashmir. But for extending it to other matters, concurrence of the state government is mandatory, as I told you before. Now, provisions for deletion of Article 370. This is interesting. How could Article 370 be deleted? Since it was, the term was temporary used in it. So, it could be deleted, but how? Article 373 permits deletion by a presidential order. Presidential order was passed in 2019 to delete it. But what it says is, such an order, however, is to be preceded by the concurrence of Jammu and Kashmir's Constituent Assembly. Remember, Constituent Assembly and Legislative Assembly of Jammu and Kashmir are two separate entities. Constituent Assembly of Jammu and Kashmir was formed to make the constitution for Jammu and Kashmir, which it made, and it got dissolved in the year 1957. Constituent Assembly was dissolved because its work was over to make the constitution. Legislative Assembly of Jammu and Kashmir existed for making laws and all. So, presidential order to abrogate Article 370 could be passed, but with the concurrence of Jammu and Kashmir's Constituent Assembly, which is not existing right now. Since such an assembly was dissolved on January 26, 1957, one view is it cannot be deleted anymore. And this is the viewpoint of the petitioners. Who will the president seek concurrence of? Constituent Assembly is not there. And since the president cannot seek concurrence of any other body and president cannot take decisions by him or herself, it cannot be deleted. This was the viewpoint of the petitioners. But the other view is that it can be done, but only with the concurrence of State Assembly. Means Legislative Assembly of the state. With the concurrence of Legislative Assembly of the state, it can be done. The Legislative Assembly of the state is believed to have replaced the Constituent Assembly. And, coincidentally in 2019, when abrogation happened, State Assembly was not existing because Jammu and Kashmir was under President's rule. And when a state is under President's rule, the duties of the State Legislative Assembly are undertaken by the Parliament. In 2019, the Constitution application to Jammu and Kashmir order, the Constitution Order 2019 issued by the President, withdrew the special status of Jammu and Kashmir and extended all provisions of the Indian Constitution to Jammu and Kashmir. J&K was under President's rule at that time. So, this was the situation at that time. So, Article 370 can be taken away by a presidential order with concurrence of Constituent Assembly of Jammu and Kashmir. Constituent Assembly of Jammu and Kashmir does not exist. So some people view that this is permanent in nature. The Article 370 cannot be revoked. On the other hand, Some people say that with the concurrence of state legislative assembly, presidential order can be passed and then it can be abrogated. State legislative assembly at that time in 2019 was not existing because it was Jammu and Kashmir was under president's rule. So the president passing the order in consultation with the Parliament of India. What did the judges say? CJI D.Y. Chandrachud said Jammu and Kashmir held no internal sovereignty after accession to India. He said there was no prima facie case that President's 2019 orders were malified, means were in bad faith or extraneous exercise of power it was. It was completely legal and hence the abrogation was legal. While the court said reorganization of the erstwhile state into union territories in 2019 was a temporary move because as soon as we abrogated Article 370, we converted the state of Jammu and Kashmir into union territories, basically two union territories, one union territory of Ladakh and the other union territory of Jammu and Kashmir. He said that it was a temporary move, making them into a union territory, and directed the center for the restoration of statehood and for legislative assembly elections to be held over there. So, maybe in the time to come, that is in 2024, we may see or we may witness restoration of statehood to Jammu and Kashmir and state legislative assembly elections being held over there. A few days ago, I think on 8th of December, we covered that Jammu and Kashmir reorganization bill in which number of seats in the state legislative assembly has been increased. There are now 90 seats in Jammu and Kashmir. 24 seats in Pakistan occupied Kashmir also has been claimed by Government of India. So this makes total of 114 seats, and Ladakh will remain or has its separate constituency having separate seats. So this is what has been planned by the government, we can see. Now Justice Kaul recommended in his concurring opinion that Truth and Reconciliation Commission should be set up in Jammu and Kashmir for an acknowledgement of the acts of alleged rights violation in the region, because these petitioners also claim that after the abrogation of Article 370, human rights of the people are being taken away in the state of Jammu and Kashmir. So, Truth and Reconciliation Commission can be formed for inquiring into this claim by the petitioners. Now, what did the petitioners claim or argue? The petitioners had four broad questions or four broad agendas on which they filed their petitions in the Supreme Court. The first is on the sovereignty of Jammu and Kashmir. The petitioners said that Jammu and Kashmir is sovereign, whereas in the overall judgment we just saw it in the previous slide that CJI D.Y. Chandrachud is saying that there is no internal sovereignty given to the state of Jammu and Kashmir. The petitioners had argued that Jammu and Kashmir retained an element of sovereignty when it joined the Indian Union in 1947. This arrangement, they argued that, was distinct from the relationship with other princely states that merged with India. There were around 500 to 550 princely states that merged with India during that time. And they said that the way in which Jammu and Kashmir was merged into India, it enjoyed certain internal sovereignty. But what did the Supreme Court said on this claim? It noted that Article 1 of the Constitution of India provides that India is a union of states. Article 1 references Part 3 states, and Jammu and Kashmir was listed as Part 3 state before 2019. Now, Section 3 of the Constitution of Jammu and Kashmir, now we are talking about Jammu and Kashmir Constitution only, which declared that Jammu and Kashmir is an integral part of India. And Section 147 of the J&K Constitution again prohibited any amendment to Section 3. Means this Section 3, which claims that Jammu and Kashmir is an integral part of India, it cannot be amended. Means Jammu and Kashmir will stay as an integral part of India. Jammu and Kashmir does not enjoy internal sovereignty. Then Justice S.K. Kaul, in his concurring opinion, held that Jammu and Kashmir retained an element of internal sovereignty. Now, one of the judges said that, Jammu and Kashmir retained an element of internal sovereignty despite Maharaja Hari Singh signing the instrument of accession with India. He cited the recognition of this internal sovereignty in Article 370 when it recognized the Constituent Assembly of the state. No other state in India was having its own constitution. No other state in India had its own constituent assembly except for Jammu and Kashmir. And in this sense, there was some element of sovereignty present with Jammu and Kashmir. This is what the Justice Call said. However, this had no bearing on the final conclusions reached by Justice Call. Justice Call was in favor of the abrogation of Article 370 only. Now, the second question on whether Article 370 is temporary or permanent. Now, since it is written temporary in the heading of Article 370, so that was also questioned. The petitioners argued that the provisions could not be abrogated, means Article 370 could not be abrogated since it had attained permanence, and as the original part of the constitution forms the basic structure which cannot be tinkered with. So the petitioners were equating Article 370 or making it part of the basic structure of the constitution. Basic structure of the constitution, as mentioned in the Case 1 and Bharti case, cannot be amended. Senior advocate Mr. Kapil Sibal argued that since 373 prescribes the recommendation of the Constituent Assembly of the state, which ceased to exist as a prerequisite to abrogate Article 370, its abrogation is essentially infructuous. I've told you many times, but yes, again I'm repeating that Mr. Kapil Sibal is saying that Article 370 can be abrogated with concurrence of the State Constituent Assembly. The State Constituent Assembly, since it is not existing, so it is making Article 370 permanent. It cannot be abrogated. This means no constitutional means exists to abrogate Article 370 once the J&K Constituent Assembly had ceased to exist. Now, the Supreme Court on this particular claim, the opinions of both CJI and Justice Call held that Article 370 was always meant to be a temporary feature. Now, what Justice Call said, he held that Article 370 is meant to be a temporary agreement or arrangement. It cannot be said that mechanisms under Article 373 came to an end after the State Constituent Assembly was dissolved. There would be some or the other body which will take the position of Constituent Assembly. So it is like this. The CJI said that there were two aspects that showed the temporary nature of Article 370. First was, it was intended as an interim arrangement until the Constituent Assembly of the state was formed. And the second was, provision was adopted because of the special circumstances in the state which was experiencing warlike conditions when Pakistan attacked Jammu and Kashmir. So this Article 370 was given, it was always temporary in nature. The third big question, or the third argument or claim of the petitioners was that the abrogation of Article 370, was it legally abrogated? The procedure adopted to abrogate it. Now, we look into the procedure first of all, which was involved in abrogating it. Now, on August 5, 2019, the President Ramnath Kovind issued two constitutional orders. First constitutional order was Constitutional Order 272, which amended Article 367 of the Constitution. What is Article 367 of the Constitution? It deals with interpretation of the Constitution. And Constitutional Order added a new meaning to Constituent Assembly of Jammu and Kashmir. See, in Article 373, it was written that it can be abrogated by the presidential order in concurrence with the Constituent Assembly of Jammu and Kashmir. Now, Article 367, which deals with the interpretation of the Constitution, it was amended first by a constitutional order issued by Ramnath Kovind to mean Legislative Assembly of Jammu and Kashmir. Constituent Assembly of Jammu and Kashmir was replaced by Legislative Assembly of Jammu and Kashmir according to this Constitutional Order 272. Means that 370 can be abrogated by the presidential order by taking concurrence from the Legislative Assembly of Jammu and Kashmir. Now, since Legislative Assembly of Jammu and Kashmir was not existing because Jammu and Kashmir was under President's rule, so let's see the next presidential order. What did it say? Constitutional Order 273 was promulgated seeking the consent of Parliament, which had assumed powers of the J&K legislature since J&K was under President's rule. So basically what happened? Article 370 could be abrogated by a presidential order, but presidential order had to take concurrence of the Constituent Assembly of Jammu and Kashmir. Since it is not existing, Constituent Assembly of Jammu and Kashmir has been replaced by Legislative Assembly of Jammu and Kashmir. Legislative Assembly of Jammu and Kashmir was for the time being not in existence because of the President's rule. Now, the Parliament of India had to recommend the President to abrogate Article 370. And this is what, legally the government did by passing these two constitutional orders, Constitutional Order 272, Constitutional Order 273. And after that, the Article 370 was abrogated. It was a well planned and I would say legally sound move taken by the government. It was not taken in the air because the government very well knew in 2019 that this step of ours is going to invite a lot of legal repercussions. So that is what the government thought about it. Now the Supreme Court on this claim of government doing this all encircling and all. Now Justice Kaul upheld this process, whereas CJI Chandrachud said there was no need of this circuitous route to be followed. Of first changing the meaning of Constituent Assembly of Jammu and Kashmir, it was not needed. Essentially, after the Constituent Assembly of the state ceased to exist, the president could have always unilaterally abrogated Article 370. This is what the CJI said. He said that there was no need. Aapne itna sab kuch kiya, there was no need of that. The president, on the recommendation of Constituent Assembly, was empowered to abrogate Article 370. Constituent Assembly is not existing. President can take it unilaterally. Nobody has taken away this power from the president to abrogate Article 370. This is what the interpretation of CJI D.Y. Chandrachud was. So, it was like this. And the fourth big, I would say, claim or argument by the petitioners was that, the action that was taken under President's rule. Now, the petitioners had argued that Union took irrevocable action without the state's consent of abrogating Article 370. Here the challenge was the extent of power that can be appropriate when Article 356 is in operation. Article 356 is talking about or talks about President's rule or state emergency. So, unilaterally the central government took this decision without the state's consent. Now, the Supreme Court on this claim, both the CJI and Justice Kaul cited the 1994 ruling in SI Bommai versus Union of India case. This SR Bommai versus Union of India case is a landmark case when it comes to proclamation of state emergency or president's rule in states. This case defined the contours of proclamation of president's rule. In what cases, in what circumstances president's rule can be proclaimed. Who can proclaim it? In which way it can be proclaimed. Relying on the Bommai ruling, the court said that standard to decide the validity of president's action was to see whether it was not malified or palpably irrational. And the Supreme Court judges said that it was not malified, the president's decision. It was not irrational. There was some logic in that. Advisability and necessity of the action was not born in the mind of the president. All these things were not there. The action was not malified, were not taken with bad intentions. So it is okay. The court also held that the petitioner and the union government must show malifieds to the court. The petitioners were not able to show malifieds to the court. That is why the president's actions were considered as not malified, means not with bad intentions. So these were the four, I would say, broad claims by the petitioners who challenged the abrogation of Article 370, and the Supreme Court on all these four claims, what it said, I have brought it in front of you. Article 370's details, I have brought it in front of you. The historical aspect of Article 370, I have brought in front of you. Now the question is, can Article 370 again be introduced in the Constitution? Well, to answer this question, yes, it can be introduced. But the court highlighted that it cannot be introduced by merely a presidential order like it was introduced earlier. It has to be introduced by a constitutional amendment. Constitutional amendment which would require two-thirds of the majority of the parliament in both the houses and 50% of the states voting in favor of it, which I would say is kind of next to impossible. Because if special status for Jammu and Kashmir would be demanded, then why would other states be left behind? Bihar would say that I want it, Punjab would say that I want it, Gujarat, Tamil Nadu, every other state will say that I want. So maybe the states will not agree to this situation. So this is the entire story of Article 370, how it got abrogated. What were the arguments? What were the answers to those arguments by the Supreme Court? But not only 370 was abrogated, along with 370, Article 35A was also abrogated. Now, Article 35A of the Constitution, which gave some, I would say, special privileges to permanent residents of the state of Jammu and Kashmir. Special privileges like appointment in the state governments, permanent residence, right to property, right to settlement over there. And those people who are not permanent residents, they were not allowed all these, I would say, privileges. Now in August 2023 only, when the Supreme Court was hearing, the CJI, that is Chief Justice of India, clearly cited that Article 35A denied many rights to the people in J&K. Hence, its abrogation is rightful. Article 35A, in its substance and in its content, it was written that it is immune from any I would say constitutional interpretation, because it was clear that Article 35A is violating many fundamental rights like Article 14 and 19, 20, 21. But since it was written in the content of that particular article that it is immune, so it remained immune. That was Article 35A. So let us look into the details of this. Chief Justice of India D.Y. Chandrachud said Article 35A, which empowered the Jammu and Kashmir legislature to define permanent residents of the state and provide them special privileges, denied fundamental rights to others. Now, who are permanent residents? Permanent residents are those people who had been residing in the state of Jammu and Kashmir in the year 1927, or their ancestors were residing in 1927. In 1927, there was a survey conducted by the Maharaja Hari Singh, or the ruler at that time. And according to that survey, who were, domicile of Jammu and Kashmir at that time were only considered as permanent residents. Apart from those, no one else. And those permanent residents only had all the privileges. What kind of privileges? These three privileges: right to equal opportunity of state employment, right to acquire property, and right to settle in Jammu and Kashmir. The non-permanent residents were not allowed or not given these three, I would say, privileges. Article 35A gave special rights and privileges to permanent residents only. How was Article 35A inserted? It was introduced through a constitutional order in 1954 issued by the President under Article 370. That is why it is, related to Article 370. Article 370 was abrogated. Along with it, Article 35A was also abrogated. Was Article 35A inconsistent with other articles and constitutional provisions? Yes, it was definitely inconsistent with these constitutional articles, or we can say fundamental rights. Article 14, right to equality. Article 19, freedom of speech and expression. Article 31, then it was considered as right to property, but later it was removed. Article 21, right to life. Article 22, protection against preventive detention. Article 35A was in contravention of all these fundamental rights. But Article 35A had even granted immunity from judicial review. Means, even if Article 35A is in contravention with other constitutional provisions, it cannot be questioned in any court of law because it had immunity. Okay. So it was like this. Now, impact of removal of Article 35A. Many people who migrated to Jammu and Kashmir after 1947, like many people from POK, who were ousted from POK, they came here in Jammu and Kashmir. They were not given permanent status, and they were not having all those privileges, those three privileges: right to settle down, right to own a property, or right for government employment. Now, what was the impact? People, both Hindus and Muslims, driven out of Pakistan occupied Kashmir in 1947, were not recognized as permanent residents until 2019, when Article 335A was abrogated. Permanent residents of the erstwhile state included people who were hereditary state subjects in 1927, when Jammu and Kashmir was a princely state. The large population of Safai Karamcharis brought to Jammu and Kashmir for manual work were not given this status despite residing in the state for many years. Article 35A had been a hindrance to the growth and flow of investments into Jammu and Kashmir because, many economic entities or factories, or let's suppose any other business houses, they were not allowed to settle, or they were not allowed to acquire property over there. So they could not take their businesses over there. That was a big hindrance. Despite this, the class of people known as permanent residents were misguided into believing that they were enjoying a privilege that none could take away from them. The people there, they were given this false hopes. Now, I was watching a video of one of the IAS officers who is from Jammu and Kashmir. I'm forgetting his name. I think Athar Amin or something like this. I'm not so sure about the name. But yes, this video is there on YouTube. He said in that video कि आर्टिकल 370 जब था तो हमें ये बताया जाता था कि ये आर्टिकल हमारा है, सिर्फ हमारा है, और किसी के पास ये राइट्स, ये प्रिविलेजेस नहीं है. पर जब ये हटा आर्टिकल 370 फ्रॉम जम्मू एंड कश्मीर, तब हमें रियलाइज़ हुआ कि ये आर्टिकल हमारा नहीं था, ये हमारे अगेंस्ट था. इसने कोई डेवलपमेंट होने नहीं दी, लोगों को भ्रम में रखा. It is like this, as claimed by that IAS officer. And after the abrogation of Article 370 in Jammu and Kashmir, we can say all the indicators of terrorism at an all-time low, all the indicators of development at an all-time high. We just hope and pray that the situations in Jammu and Kashmir become more and more, I would say, vibrant, become more and more prosperous. That state should also be in line of other states like Punjab, which was struggling with terrorism in the 1970s and 80s, but is now one of the most prosperous states of the country. If Punjab can do it, Jammu and Kashmir definitely can do it, having immense potential of tourism. So, this is how things need to be tackled with respect to Article 370 and 35A. And with this, we've come to an end of today's session. I will now be meeting you tomorrow with more such informative news pieces. Till then, you guys very well know what to do. Keep studying, keep reading, keep writing, and most importantly, keep revising. Namaste. Jai Hind.